It's page.
My lady, just a quick point before I resume on the counterclaim, which is, as I highlighted when I started yesterday, I wanted to make a reference to the timing of the tweets on the 4th of October. I picked it up just because of that being something that was said by my learned friend before he sat down. And he criticised the judge for her remarks about Mr. Fox singling these three out for his paedophile response. And he complained of some references in her judgment. I think there were three, the ones that I identified in paragraphs 95 and paragraph 120 in particular. And his complaint was, as I understood it, that she ignored the fact that he responded as he did because they were the three that ignited this spat, and that she had treated him as having randomly, arbitrarily selected three people to be unpleasant to. Now, overnight, and it may be, hopefully is on your tables, we've just extracted the relevant pages from Mr. Fox's exhibit to his first witness statement, so this was in evidence at the trial, just to capture the tweets that he disclosed that took place on the 4th of October. Now, some of them have no timing on them, but there is a point where the timings kick in. It's not clear whether these have been arranged by somebody on the premise that this is the order on the 4th of October, but those that do have a time on it definitely are ordered chronologically. So we gain very little from the first few pages, other than the second tweet on the first page, page 142, certainly is a tweet that is tagging Mr. Fox, and it is also tagging Sainsbury's, and it refers to any sensible person will see Mr. Fox as a racist opportunity seeking his 15 minutes of fame. And one sees there that he has screenshotted, if that's the right term, the Mail, Laurence Fox, says he is boycotting Sainsbury's for promoting racial segregation and discrimination after it announced support for Black History Month. Now that, as I understand it, the Daily Mail published that story at 15:26 on the 4th of October, so before any of the claimants' tweets. So the story, the national media story, was started by the Sainsbury's boycott tweet. That is what started the spat. And so next day, the Mail is continuing the story, but it's become a story about his paedophile responses. So that is a possibility that 4th of October tweet may be earlier, but we don't know. Just over the page at 143, again, we don't have dates, but we've got, again, tagging of Mr. Fox and Sainsbury's, and certainly from the second two on that page, what people are understanding, or these people are understanding, is that he's criticising Black History Month, because as I explained, that, of course, was how it looked if you didn't click through the link. And so other people didn't click through the link either. But if we then go to page 145, we get the first one in which it's been captured with the time on it. And the top one on page 145 is 4:01 p.m. So 3/4 of an hour before the first of the claimants. Now it's true it doesn't tag Mr. Fox, but it's clearly about Sainsbury's and describing Mr. Fox as an attention-seeking racist. And one sees there from the metrics below that it attracted 90 replies, 907 retweets, and 4,500 likes. So very substantial engagement before Ms. Thorpe joins in the foray. And then the second one down there is David Burgess, and that is at 4:45. And then we've got others, which I don't draw attention to, but we've got the timings on them. Others denouncing Mr. Fox as a racist on 4th of October. So I just wanted to deal with that point so that it didn't get overlooked, having mentioned it yesterday.
And just to be clear, the position evidentially is that he didn't reply to any of these.
That is my understanding. Well, certainly the judge's understanding. She singled.
That's the basis of her singling out.
So putting that aside, I want to return to the counterclaim. Now, I'm determined I'm going to sit down at midday for Mr. Soutal to deal with damages, so I'm going to go as fast as I can, but I'm saying a lot more about the counterclaim than I am about grounds 4 and 5, because I believe I can deal with them quite quickly. But although I'm going fast, I hope nobody will hesitate to ask for any clarifications. Now, when I concluded yesterday afternoon, I had taken the court to Mr. Fox's particulars of serious harm at paragraph 88, where he referred to prior instances of people on Twitter calling him a racist before the Claimants, and that his case on harm was that it emboldened many more individuals to do so, and he gave just one example, the example of Miss Trey, calling him a racist on Twitter over 5 months later, apropos nothing on his face to do with the Claimants, Sainsbury's, or paedophilia. And I showed you also that he complained of the media reports of the 4th of October dispute, giving wide publicity to the racist allegations as further damage to his reputation. And that was his paragraph 80, subparagraphs 8, 9, and 10, core bundle, pages 230 onwards. Then I showed the court how, in response to causation of serious harm, the defendant to the counterclaim cited a paragraph 28.3, the 15 tweets between 2nd of February and 27th September 2020. I didn't get to paragraph 28.5 of the same pleading, and that is at page 255 of the core bundle. So in responding to his complaint about the allegations against him getting wide publicity and adding serious harm, he made a number, it was said in this paragraph. Further, it's about 4 or 5 lines down. Further, Mr. Fox made a number of highly controversial statements about race prior to the 4th of October 2020 and thereafter. This is a matter for evidence in due course. Then at 28.8...
Can I just ask what the legal relevance of that is in your submission?
Well, of course, because I'm going through the pleading sequentially, I haven't actually addressed the question raised yesterday about how his case was put.
Yeah. Okay. Well, you've taken it in your
yes,
own time.
I'm sorry.
I don't want to take you out of your course.
But I think we get it clearly when we get to the written closing.
Right.
Because of course, because the issues evolve from the pleadings through the trial to the written closing, and that's the case that the judge is directing herself to determining. But this is in the context of causation. So in terms of where it is in the pleading, it's relied on causation of serious harm. It's a response to paragraph 80. And then at 28.8, at page 256, reliance is placed by the claimants to rebut his case that they were responsible for this serious harm he claimed his career had suffered. And they relied on, for example, in one, his appearance on Question Time become notorious, his Spectator article. 3, his being cancelled, according to him, in June 2020. Over the page at 4, establishing a new political party. 5, they challenged the Sue Latimer causation claim. Now, the Sue Latimer causation claim is pleaded by him at the end of his particulars of serious harm, but it might just be worth noting that he notified that he would be counterclaiming on the 28th of October before Sue Latimer had terminated the agency relationship. And then at 28.9 on page 257, accordingly the defendant has put to proof of the allegation that the claimant's tweets had any impact on his career, given the claimant's own public statements, including the controversial remarks as to race and his focus on political activities and a possible political career. So what one can see that is directed to is the impact on his career, it is how it is put. And then finally, in this pleading, we have the plea of general bad reputation. If we go to page 266, paragraph 33.4, it's just one sentence relying on general reputation as racist as at the date of publication of their tweets and afterwards added by amendment. The first point I'd make is that there is no reference back to the 15 tweets. There is no, or to 28.3. While we're looking at and afterwards, just to deal with the point of complaint made by Mr. Green yesterday, and I should say about some of these forensic points that he made about disclosure, about things that should have been in particulars of claim and weren't and so on. They had every opportunity to take these points, whether on the CCMC, on the PTR, with the judge. If they didn't take them, they didn't take them. If they took them and they had an order against them, and they didn't like the order, they could appeal it. But they did these points, there were no findings at any stage about the defaults. So these are points that really don't assist on an appeal. But just to deal with that, it was because Mr. Green has suggested, as I understood it, that they didn't realise that general bad reputation was no longer in play, notwithstanding the fact that it wasn't in the list of issues. And he cited the date of this pleading, which is 6th of November. Now, this draft amendment was put forward on the 2nd of October, as I understand it. And sometime shortly before that, shortly after that, the defendant side said that they would not object to the amendments. But the court's sanctioning of the amendments, the order, didn't take place until the adjourned PTR on the 6th of November. By then, the list of issues had come and gone, and it was clearly not being pursued. But it doesn't get served until the 6th of November. So really, there can have been no question, at least from the service of witness statements, that general bad reputation, whatever might have been the intention, in early October, had long gone. Now, in his reply to the defendant counterclaim, Mr. Fox responds to paragraph 28, the paragraph about why harm wasn't caused. And if we go to page 269, and 269, paragraph 6 at the foot, is a reference to the paragraph with the subparagraph 15 tweets, and it's clearly stated here, are legally irrelevant evidence on such matters is admissible. It's not permissible for a defendant to rely on publications by other people containing the same or similar allegations in order to mitigate damages, and they therefore decline to plead. And then at paragraph 7, as to the claimant's reliance on his controversial statements before and after October 2020, they don't take so much a specific legal point, that they say pending the provision of proper particulars, including an explanation as to relevance, the defendant cannot omit or deny. And they also questioned the relevance of the question time, notoriety, spectator equity, and those things we saw. Now then, to continue the story of the 15 tweets, as it was visible to the judge, as the trial judge, there was no application to strike out at the pleading stage, or at the CCMC or the PTR. There was no application to strike out at the trial. There was a mention in Mr. Fox's trial skeleton argument, which we need to go to volume 4, which we're going to stay with for a while.
Sorry, 4.
Volume 4, tab 4 for my lady, page 92. So page 92. This is this is the skeleton argument of Mr. Fox for the trial, and it's his section on the claimant's case on serious harm in the county.
Sorry, I've lost what paragraph?
Page 92, paragraph, 111.2, subparagraph A. And this is the only reference to Dingle for this purpose in the trial skeleton argument, and it simply says it's in breach of the 28.3 is in breach of the rule in Dingle and is demurrable. Dingle was, as I said yesterday, and we see it in the paragraph immediately above, 111.1, Dingle was being relied on to say that for instance, as I suggested, C1 couldn't say the harm was caused by C3, because that would be offended by the rule in Dingle. And that was the only other context in which Dingle was relied on. But I would say in relation to that point about claimants inter se, if Mr. Fox was running a case purely on gravity of imputation and extent of publication, he wouldn't need to worry about that, because they would be, each one would meet the inferential case if that was the case that he was running. But anyway, to stick with 28.3 and the 15 tweets. So that was, as I say, a brief, uninformative mention, and merely telling the judge it was demurrable, but no application to the judge. As I said, the only other reference to Dingle, paragraphs 104 to 109, on that distinct point about the claimant's tweets inter se. So no ruling sought. Now, on day 4, as the claimant's case was concluding and Mr. Fox beginning, the documentary evidence of the 15 tweets, which Mr. Fox's team had refused to have in the bundle, were provided to the judge by the claimant's team in the short adjournment, electronically, and then physically by the print copy which is to be handed up in court. And no objection appears to have been made. Certainly this is part of the story told in Malone Friend's skeleton argument, and they don't say that any objection was made. Mr. Fox duly goes into the witness box, and his cross-examination made reference to the 15 tweets, including specifically to, by name, paragraph 28.3 of the defence to counterclaim without objection. Now, merely because of time, I'll merely give the references to the cross-examination, because when we get to the written closing, we can see that the cross-examination is commented on in Mr. Fox's closing. So the references are these, the cross-examination, bundle, they're all bundle 5, page 233, transcript pages 186 line 9 to 188 line 6, and that's that one is where there's express reference to paragraph 28.3. Bundle page 241, transcript page 217 lines 4 to 6.
Sorry, can you give that again?
Yes, bundle page 241, transcript page 217 lines 4 to 6. And then bundle page 244, transcript pages 229, lines 17 to 24. And there was also cross-examination about Ms. Trey's tweets, the only post-4th of October Twitter denunciation of him that was pleaded in reliance of the harm manifested in people calling him a racist. Hers was 5 months later, and the reference to the cross-examination is page 249, again of bundle 5, and the transcript is page 252. And one sees the exchange there in which it was put to him by Miss Skinner that nothing on Miss Trey's tweet to differentiate hers from all the racist denunciations of him before the 4th of October, that there was nothing to differentiate. And in effect, the only differentiate between the stream of racist denunciations before, the stream of denunciations was that some were before 4th of October and some were after 4th of October. And nothing about Liz Trey's tweets was probative of 4th of October having anything to do with her being prompted after 4th of October to tweet. And if we now then go to the day of closings, so as I understand it, the day of closing started with the parties having finally reached partial agreement on a chronology which was provided to the judge, and reliance is placed on it by my learned friend for the reference to the 15 tweets. So let's look at it. It's in bundle 4. It's tab 8, page 157. And it's entry number 20. It's got various dates, previous tweets accusing G of racism, D comment, inadmissible per ruling Dingle. So it's a very uninformative entry, considering that the judge is being criticised over this, tucked away. It wasn't flagged to the judge in closing written or oral submissions. there is no reference to 28.3, the defence to counterclaim, to assist of what's being referred to here. On the face of it, it might be understood as some objection to something that might have been sought to be relied on as general bad reputation. But I would suggest that it is unfair to criticise the judge for referring to the 15 tweets on the basis that she knew from this entry in the chronology that they were objected to, even though no ruling had been sought and they had been cross-examined upon by that stage. So we put the chronology away. If we now go to the claimants' written closing, I think they're all dated 1st of December, which is the date of the closing. And there's one passage, still in volume 4, tab 9, page 200. And it's paragraphs 662 to 64.
Sorry, which page?
Page 200.
62 to 64.
Oh, sorry, paragraphs. Page
Yeah.
200.
Yeah, I got it.
To 200.
Under publication of the Sainsbury's tweet.
Tweet and reporting. So there's something about the Sainsbury's tweet which just cast your eye about, on its face. Already made this admission. It outed himself as a racist by accepting Sainsbury's invitation to shop elsewhere, calling for other racists to do so. And then at 63, it's readily apparent from the content and tone of the media reporting that followed that it was the nature of the defendant's conduct in making the allegation against Sainsbury's and then calling the claimants paedophiles, rather than that of the claimants in calling him racist, that drew the attention of the press. They cite the events from the chronology. As the defendant himself acknowledges witness statement, and as itemised in the claimant's pleading at 28.3, the defendant had received a tsunami of abuse following question time being called a racist on at least 15 previous occasions during 2020. This the court will also bear in mind the unchallenged evidence of Ms. Thorpe that very many Twitter users were calling Mr. Fox a racist that night. None of them were reported on because the defendant did not respond, calling them paedophiles. Faced with these difficulties in evidence, Mr. Fox stated for the first time that it was Ms. Thorpe's tweet in particular that was damaging to him because, like him, she was also in show business and his community is a small one. If true, this would be a point of considerable significance and would have formed a central part of the defendant's case. Even if for some reason it had not been pleaded, Mr. Fox would be expected to avail himself of the opportunity to make at least passing reference to it in his witness statements. He did not, because it is not true, as Ms. Thorpe explained. She did not, as of October 2020, have the kind of influence, especially in relation to Mr. Fox, a member of the famous Fox acting family. Now, in his submissions yesterday, Mr. Green relied on aspect of her career, and what he took was what was in paragraph, what he repeated was what was in paragraph 11 of her witness statement. I don't know that we need to go to that. I'll just reference it, where she is talking about 2 years later. So the Jeremy Kyle show and the things he listed are all what her career was in April 2022, not what her career was in April 20. I now want to go to the defendant's written closing, same bundle, tab 10, page 282.
Sorry, page number?
Page 282.
Thank you.
And this is where we see how the case was put on serious harm by the time we get to trial. There's quite a lot to cover. So starting with the opening shot as to what the case is. We have it in paragraph 165. Putting aside the thornier question of causation considered below, there can be no real dispute. Mr. Fox's reputation has been seriously harmed since October 2022. This harm is evidenced both directly through his loss of his well-known agent, Sue Latimer, and the documented decline in quality and quantity of acting roles and other business opportunities offered to the defendant after October 2020, and two, indirectly by inferences to be drawn from a clear factual foundation. At that point, it's not entirely clear what the factual foundation is there, but we come on to see what there is that goes beyond Ms. Latimer and acting. And then at paragraph 166, he refers back to his defence and counterclaim, and 166, the claimant's case in response can be found at paragraph 28. And of course, paragraph 28 includes paragraph 28.3, and is not flagged up to the judge there's any problem about paragraph 28 or any aspects of paragraph 28. So I would have thought an opportunity might have been taken here to say that she should take no account of 28.3 and why she should take no account of it. But she's simply told that paragraph 28 is on the agenda. And then it goes straight into the defendant's documentary case. This is not, so he doesn't start with an inferential case, he starts with a documentary case. And the documentary case is based on the appendix to the trial skeleton argument, which is described as capturing the serious decline in business. And then the subparagraphs that follow are unpacking what they say is shown by the documentary case, and it goes on until the following page. And then at 168, whilst Mr. Fox has produced documentary evidence of a loss of business opportunities, he's not pursuing a special damages claim. This has two important implications. The defendant is not required to demonstrate particular roles and opportunities were lost as a result of the claimant's tweets. The decline in roles contributes to a holistic picture of his declining reputation. So in other words, it contributes to proof that his reputation had suffered. So that is not so far an inferential case, or his primary case was not gravity and extent of publication, full stop. Failing that, I have some adverse consequences. His primary case is that you can identify that he suffered serious harm, but by reason of the career consequences. And of course, he is, on the other hand, in response to the claims, challenging the ability for them to have an inferential case based on gravity and extent of publication. So he's a bit hamstrung in how he puts that. He was arguing, and argues today, they had to show consequences. So clearly, he had to pin his case on consequences. And then over the page 168.2, he says the fact that Mr. Fox didn't sign with another agent is irrelevant to whether he in fact suffered serious harm without a special damage to be clearly relevant to mitigation, to which I've made this point, I think, already, that if you don't have an agent, that might be why you lose offers, in which case the loss of the offers proves nothing about the state of your reputation and doesn't evidence of itself any change in your reputation. And then at 169, he turns to the extraordinary white wolf letter that was sent to Reclaim Party headquarters many months later, and the feces through the door. And he puts that ahead of the next section, which is inferential case. He then, at 170, in addition to this clearly documented serious harm, the defendant relies on the general inferences of fact drawn from a combination of evidence about the meaning of the words, the situation of the claimant, the circumstances of publication, and the inherent probabilities. And he cites the judge's judgment in Civ and Anthem. And that is exactly the exercise the judge did. And then he goes on to the vast scale of publication, but of course the extent of publication was ignited by his Sainsbury's boycott, as received in the Daily Mail, and then added to by his paedophile responses. And then he has the gravity of the allegation, and one sees casting down just below, halfway down the paragraph, he has explained he considered it to be career-ending. But as we saw yesterday, he'd said before that his views were potentially career-ending long before these tweets occurred. Then, over the page, the allegations plainly come to the attention of people who know including most importantly, this latter, and then the failure to apologise. And so he has the documentary decline, and then he adds an inferential case based on the show of factors. And at paragraph 171, he says the counterclaim requires the court carefully to assess the question of causation. This is because, one, there's an inherent difficulty of isolating damage caused by each of the claimant's tweets. And like I said, each of the claimant's tweets had gravity and circulation. Secondly, there are competing factors that the claimant has suggested supposedly to explain the sharp decline in the defendant's reputation after October 2020. So his case was not that you can take the claimant's allegation and say the first claimant's allegations and impressions, and infer from that alone that they cause serious harm. So he relied on it being the impact of all three. And so in 172, he deals with Dingle in the context of the claimant's inter se. And then at 173, the defendant has explained that the serious impact of the tweets was because of their combined effect. A perfect storm of all three people repeating the same allegations, triple-pronged attack from three people with a combined audience. So if his, it's not his case that any one of the claimant's tweets caused the serious harm. It is taking them all together. And he is invoking in order to address competing factors. Over the page, paragraph 124, he then makes the thought.
Sorry, paragraph which?
174, sorry.
174.
174.
Thank you.
They bring in the new point that came up only in cross-examination about Miss Thorpe being somebody in his business, who turned around and said these things. And then the commentary after the quote from the cross-examination. This was the cross-examination about the 15 tweets. Mr. Fox explained that Ms. Thorpe's status in the show business industry distinguished her remarks from other earlier occasions where he had been called racist by people on Twitter, as set out in the defence to counterclaim. That is a reference to paragraph 28.3 of the 15 tweets. Paragraph 176, he then identifies the competing causative factors that says the judge has got to carefully consider on causation in order to make good his case on serious harm. And he says Mr. Fox has firmly in mind his burden to demonstrate via evidence a cause and effect link between the defamatory publications and his impacted reputation. Now, just pausing there, he doesn't say a cause and effect link just to Ms. Latimer. He says to the impact on his reputation generally. The claimant disputes this link exists for the following reasons. Firstly, 1761, that the harm to Mr. Fox's reputation was caused by his own behaviour, including behaviour predating the tweets, such as his appearance on Question Time. And of course that embraces, that is an example of all the ones that were in play. And secondly, the defendant's own tweets on the 4th of October. So in other words, his Sainsbury's boycott tweet and his paedophile riposte. So the judge is being told by Mr. Fox's side that he has got to demonstrate that the harm was not caused by those factors. Then 1762, after 2020, Mr. Fox shifted his primary activity and acting to politics. So again, that was in play as a reason, and then a point that wasn't apparently pursued. And then at 177, the court is invited to reject these reasons. There is a clear body of documentary and testimonial evidence permitting the court to determine on the balance of probabilities that the claimant's tweets caused the significant decline in the defendant's reputation, which in turn manifested in the termination and the decline. So the case there is the documentary and testimonial evidence that is relied on to demonstrate the significant decline in his reputation. So this is a general case in which the termination and the decline is the manifestation that harm had been caused. Now, this is followed by several pages worth of addressing this all as a factual issue to be determined by the judge. Now, over the page at 288, I'll just draw attention to a few points. There's paragraph 178, theories put to Mr. Fox during cross-examination that he'd already been shunned work-wise, his cancellation occurred after BBC Question Time, that the termination of the relationship has nothing to do with the claimant's tweets. And it said Mr. Fox consistently denied this proposition, emphasising that it was being called a racist by a member of the show business community, which forced Miss Latimer to make this decision. And then at 179, the causal link between Miss Latimer's decision and the claimant's tweets, rather than the defendant's own tweets or events predating 4th of October, is established on the evidence. So these are events predating 4th of October, his own tweets, all this is in play, not said to be ruled out on any point of law. And then there are then pages after devoted to arguing the toss on the facts and on the evidence. So if one goes over to page 289, for example, paragraph E, there's a reference to something he said on the 30th of September email to Miss Latimer, and going down 4 lines. In evidence, Mr. Fox has persuasively explained that this does not prove his reputation had been seriously harmed before the claimant's tweets, and so on. So he understood, demonstrated it's terribly important to causation in order to establish serious harm and liability. Over the page at 290, there is sought to be invited an irresistible inference from the timeline that the event that caused Miss Latimer to terminate occurred on the 4th of October, and that the decline in business opportunities followed directly, as well as from the general decline in his reputation. He then deals at 181 with the media publications. And so it goes on. All these things that were in play, all these things that were part of what are now criticised as counterfactuals by, on this appeal, but were looking at the potential candidates for the harm that, in the judgment, are all being argued at great length as points of fact. At 182, at page 291, paragraph 182, there's the media coverage gone into, then the political career gone into, and then at 293 we arrive at the conclusion presented to the judge in the written closing, and it is said a conclusion on serious harm on the counterclaim. 184, there is more than sufficient evidence for the court to find that the claimant's tweets caused serious harm to the defendant's reputation. In summary, and they start again with a documentary body of evidence proves that he suffered serious harm to his reputation, manifesting in what we've seen. And then at subparagraph 2, there is sufficient evidence for the court to be satisfied of a causal link on the balance of probability between the claimant's tweets and this decline. So he relies on him being offered opportunities throughout 2020, his relationship with Latimer remaining positive, and that he gets an opportunity 2 days before the courts. Nothing here about an inferential case based on primary factor, single meaning, and extent of publication. So the primary case is an evidential case. It is a case on facts. It is not extended inferentially beyond the documentary evidence and the termination and the white wolf and the feces, other than in the context of saying, look at the other factors, inherent probabilities, and saying that there is sufficient evidence of a causal link. That is his primary case, and that is what the judge was presented with. Now, can I suggest we put this bundle away for those of us on the print and now go to what the judge said about this in her judgment as to what the case was, as she understood it.
So this is the liability judgment.
The liability judgment. So if we go to paragraph 122. Sorry, I've lost my judgment.
Tab
Oh dear, I've got it loose.
I think we've all got it anyway, don't we? Just go to the paragraph number.
Sorry, paragraph 122. So this is where she comments on it being a startling. This is under situation of the counterclaimant, which is he asked her to look at the situation of the counterclaimant, and she starts with it being a startling feature that no witness evidence for Miss Latimer, and she refers to authorities about the difficulty that the claimants may have, and she says it is no secret that Miss Latimer dropped Mr. Fox. The only question would have been why. I do not have her answer. It's not unusual for third parties to be reluctant to get involved in litigation. There are plenty of good reasons for that. But Miss Latimer's reasons for dropping Mr. Fox are put forward as the high watermark of her case on serious harm. And that is that paragraph does not get mentioned in Mr. Fox's skeleton argument, but that demonstrates how she understands the case that has been put to her, and clearly she was entitled to do so. I think there's another paragraph where she says that, but I seem to have made a note of it, anyone behind me. Oh yes, so maybe 113. I was probably thinking it's less clear.
113.
113
Yeah.
on page 136. So the last two sentences, past ones down to them. It is not essential for him to prove any of these particulars in order to establish that the serious harm test is passed, but that is the case he asked me to consider. I do so. And then, leaving the judgment, just one point before I go to the next document. While we're on the judgment, one of the points made in the skeleton argument is that she made an error of law in not approaching causation on the basis of a material contribution. So in other words, that the claimant's tweets should at least have made a material contribution. She didn't have to find that it was fully responsible. And it's the skeleton argument at 38.2, you don't need to look at it. We've dealt with this in our skeleton argument on the basis that he didn't argue it as the claimant's tweets only contributing. His case was that's what did it, hook, line and sinker. But in any event, if one still has the judgment, and it goes to paragraph 157, at page 147, her conclusion at the very end of considering the serious harm case, in the last sentence of paragraph 157, I've not been given a sufficient evidential basis for inferring that here, or for identifying any material causal connection between the impact of the tweet sued upon and Mr. Fox's reputation. And where she does talk about causal factors, she talks, where she does the supposed counterfactuals, examples of which are 146, 147 and 150, she's using the language of causative role or causative power. In other words, causative meaning a potential to cause. It doesn't have to be a potential to cause the entirety, it could be potential at all. And one other point, while we're on paragraph 157, is that she does make, we would say that she deals in 157 with the general case as well, and he says, where she says, it's just below halfway down that paragraph, if he invokes defamation law to challenge their entitlement to express their own opinions on what he says or how he says it, he has to be ready in the first place to show, by reference to evidence and inherent probability, how his reputation, what people think of him, is seriously harmful, impacted in real life by their publications, as distinct from his, or indeed anyone else's, or anything else.
Isn't that the Dingle problem in a sentence? Because that's assuming that things that he and other people have done have affected his reputation, and then he has to distinguish that from the harm caused by the publications complained of.
Yes, absolutely. But it's one thing to have acquired, to say he's got a general bad reputation, he can't suffer anymore. It's another thing to find the direct causal link and see what else might be directly.
That's your point about specifics.
To the harm.
Here,
yes.
Here the question is, is there harm, not what caused it. It's the anterior question.
Yes.
If we're dealing with the general inferential case.
Yes.
Now, I understand you say he basically put that to one side, and his whole case was, the whole weight of his case was on the specifics. But if it's legitimate for him to complain today that his general inferential case was not adequately addressed, or if it's legitimate for him to complain about that aspect of his case, isn't there some problem potentially in that sentence? Because in that sentence, the judge is not addressing the specifics about whether his career was destroyed or whether Miss Latimer dropped him for that reason. Where on the agreed law, the potential causative factors have to be considered. In this context, you've got to decide whether an inference of harm is justified without relying on harm that may have been caused by what other people said, the 15 tweets or anything else.
Well, of course, every case depends on its particular facts. And in this case, the evidence about the state of his reputation comes from his own statements about the effect on his career of his stance, the fact that he makes himself prone, we saw that in the pleading, to be denounced as a racist, the fact that he thinks his acting career is over, all these things come out of his own mouth. So it's not us saying you've got a general bad reputation, it's him saying...
I can see that, but this is quite an important point, I think. If he comes into the witness box and for whatever reason is legitimately caused to say, yes, I had a general bad reputation as a racist, I can see. Yes. You can rely on that, obviously. Yes. If he says, I was controversial and people shunned me because they thought my politics were bad or something else, isn't that just another aspect of his reputation that doesn't have anything to do with damage caused or not caused by an allegation of racism? Doesn't one have to do the sectoral analysis, as you usually do?
Well, when you're talking about isolation of harm, this is the difficulty, that of course Dingle doesn't tell us what the route might be to isolating the harm. And that is going to depend on the facts of the case. And here, on the basis of everything that came out of his own mouth, and that was in evidence uncontroversially, the question was, did the claimant's tweets add serious harm? Did they create serious harm? Which means, did they add something? Did they bring something new that amounted to serious harm? And on the facts, she has to be right, I submit, in saying that is simply not proven. Now, however one gets to it, one can't allow Dingle just to say, when Dingle is about 3 newspapers publishing at the same time, and whether or not you can say, well, actually the harm was caused by this because of the idea of the man at the breakfast table opening them all, and which one caused the harm. But here one has this most unusual case of somebody bringing a libel claim in circumstances where he says, I conduct myself in a way that lays me open and attracts allegations of being a racist. But all of a sudden, somebody else has come along from within my business and has said it, and 3 people have said it together, and that has caused me harm. So I don't have an easy answer to how one deals with it on Dingle, but you've got to deal with it on the facts. One's got to look at the practical realities and the inherent probabilities, and he asked her to look at the inherent probabilities. And how can you look at the inherent probabilities without looking at this whole trajectory, question time onwards and down? And I'm afraid that's the best answer.
Can I just ask one further question in relation to that point? I mean, he made the specific point about it was within the acting community that one tweet came from, etc. Does the judge deal with that point specifically, and where? Yes.
No, I think somebody will help me. She refers to the fact that Miss Thorpe describes herself as a Z-list celebrity. Somebody with a concern.
I can tell you exactly.
139 is being suggested.
Page 114.
Page 114. Oh, yes, yes. So yes, I was given no basis for understanding Miss Thorpe's opinion was or was likely to have been particularly influential in this matter, because it was pure assertion on the part of Mr. Fox as a late thought in cross-examination. She referred to herself at the time as a Z-list ex-soap actress and told me that a lot of others had done so too. She had already moved on from the acting world. No persuasive evidence her intervention had any particular impact just because of her acting part, and I considered it inherently highly improbable. And she told me rather ruefully she had the sort of influence attributed to her tweets by Mr. Fox. She would happily have used it to advance her acting career and had a ring of authenticity. So whatever her position was 2 years later, is a celebrity, an influencer or whatever, was nothing to the point at that time. I just wanted to then, before I finish on this particular thing, which is ground 1A and B, before I go on to opinion, which I'll do very quickly, to just look at how the ground is put in the grounds of appeal. What it is called bundle 15.
Yeah.
Page 15. So the learned judge's evaluation of serious harm to Dee's reputation was not caused by the tweets, and that they were not even a material contribution to such harm to reputation. It was not a decision available to her on the facts with particular regard to specific harm and the two items listed. So that was the ground of appeal.
While you've got 15 open, do you just want to deal with one, and what do you say on that point?
Sorry.
Because there's an A, B, and C.
Oh yes, well that's what I have been dealing
Well, I realise you've been dealing with.
Yes. So in other words,
yeah,
she made no finding of general bad reputation. General bad reputation was an issue in the trial. All the material that is now said to be offending the rules on general bad reputation was in there, as we see, up for grabs as a factual case by the time of the closing.
Factual case on causation.
On the case on causation. The rule in Dingle was only cited in relation to the 15 tweets. It was then not objected to or pursued or treated by closing as something that was out of bounds to her. Therefore, to criticise her for having referred to this in isolating damage was most unfair. And then we've got ground C, which I was going to say something very quickly on, that the judge did not say that a defamatory opinion is inherently less defamatory. And so what is attributed to her, I don't ask him to look it up, but it's Mr. Fox's skeleton argument, paragraphs 31 and 32. She didn't say those things. She didn't find those things. They rely on Mr. Justice Nicklin's analysis of the point in Morgan. I don't ask you to look at it, but it's tab, just for the reference, it's tab 21 of the Bundle's Authority, page 546, and in paragraph 3.3, he says it may be impacted depending on context. Now, where she is criticised is paragraphs 114 to 118 and 141 of her judgment. They speak for themselves. She's talking about opposing ideas in the public domain about what constitutes racism and who are the racists. Are they the woke, orthodoxy people, or are they people like Mr. Fox? And which side of the argument you were on. and this was a completely unexceptionable analysis that once you, as she said, if you know what somebody's saying about boycotting Sainsbury's, you know which side of the argument they're on. And if somebody says he's a racist, you know which side of the argument they're on. In other words, these exchanges tell you as much about the person who's making the making the allegations as the people about whom they are being made. Now, there's nothing comparable by way of context affecting the impact on paedophile. There's no contest of ideas about you're a paedophile because you do that, or I'm, vice versa. There's nobody's discussing what constitutes a paedophile, whether anyone's a paedophile. That comes completely right out of the blue as a bolt, with no context of lively contest of ideas around it, as there was about racism. So that is all I'm supposed to say on ground 1C. I want to deal quite quickly with ground 4 and ground 5.
Sorry, ground
4
yeah.
next. I'm going to be, as I said, I'm going to be brief. Ground 4 is challenge to the role of the single meaning rule. Now, there will always be cases on their facts that throw up challenges that result in parties being frustrated by technical legal rules. And in defamation, the technical rule that probably causes the most frustration is the single meaning rule. But it's baked into the common law, and the purpose of so doing was in order to avoid the necessity at the liability stage for any examination of what actual readers understood the words to mean. So evidence of actual readers' understanding of the words was and remains inadmissible, except where a legal innuendo is relied on, or in the case of a reverse innuendo, where the defendant contends that all publishees would have understood the words in a sense different to what would otherwise be the natural and ordinary single meaning. But the single meaning rule survives section 1, which means that it continues, as it always did at common law, to define the legal rights and duties between the parties. And when I use that expression, to define the legal rights and duties as between the parties, I'm using the language of Lord Bridge in Charleston. And notwithstanding section 1, the single meaning rule continues to govern legal rights and duties. Now, when the court is, and of course, so obviously, of course, because the single meaning rule governs what defences are available. But when the court is considering serious harm, the court is, of course, open to evidence that publishees did not believe the allegation. But the burden, I submit, is on the defendant to demonstrate that they did not believe it. But a different question is raised on their ground 4 submissions, which is whether, as it was submitted, the reader's understanding of the words is also a proper subject of investigation at trial, or at least needs to be proved by the claimant. But that raises problems, because that really is an affront to the single meaning rule. It's an irrelevant investigation, because if actual readers could be called to say what they understood by the words, and I'm hypothesizing at the serious harm stage after there's been a single meaning, any material departure in their answers, their understanding of the single meaning, would ex hypothesi be the understanding of an unreasonable reader. And to think about putting the boot on the other foot, could the claimant who argued at the preliminary issue trial for a Chase 1 level single meaning, but is left to demonstrate serious harm at a Chase level 2, call witnesses to say, on serious harm, to say they understood the words to mean guilt, which I say, surely not, the court surely would not permit that. And when Lord Sumption at paragraph 21 of his judgment, as we were taken to by Mr. Cowles, I don't ask to go to it again, referred to the basis of the findings of my Lord Justice Warby in the show trial that he approved as to gravity, quote Lord Sumption, the gravity of the statements themselves according to the meaning attributed to them by Sir David Eadie. And that is what the judge did here. So the single meaning rule stands for the reasonable reader's understanding. And if Mr. Fox wanted the judge to find that readers didn't believe the words, it was for him to prove it. But he didn't call anyone or put any evidence before the judge from which she could make any finding that not a single reader of the words believed them to be true. And as to whether it was necessary, that was dealt with by the judge at paragraph 83. And this paragraph 83 is the only passage in the judgment that is referenced in the skeleton argument of Mr. Fox on ground 4, where this is where she says that she observes it's not necessary for the claimants to establish the probability of readers being immutably convinced of the truth of an allegation. So in other words, she's saying I wouldn't even find it helpful to have an approach involving investigating what people believe. And she was obviously right, because on the wording of section 1, the issue for the court is whether its publication, the statement's publication, is what has caused serious harm. And just to end with one example of this, Mr. Green yesterday, in the context of the one aspect of the sequel to 4th of October for Mr. Blake, submitted to you that Mr. Blake would not have got his NHS trustee position if there was the merest scintilla of suspicion caused by Mr. Fox's tweet. And that would have been a demonstration of serious harm, but not a demonstration of belief. Now, this is, unless I'm asked to, I'm not going to say anything more about this, because I think one can't just, this is not the way to go about deciding whether or not the single meaning rule should be changed. It would be a very, very serious case, and wouldn't just be a few pages of a skeleton argument and 15 minutes of submissions to do that. Ground 5, I'm going to deal with very, very quickly and a bit scattergunny, because the submissions yesterday on ground 5, which are all about trying to demonstrate that this judgment was perverse, picked on lots of bits and pieces. It seemed to be, a lot of it was a complaint that she didn't grapple with metrics, or she didn't explain that she had rejected Mr. Blake's case in relation to MFHA. She doesn't need to give a complete blow account. She needs to set out what she has relied on and how she's arrived at her conclusions. And I was going to do it by having ground 5 up. I've got ground 5 up in front of me, which I think you have probably at page 16, probably, ground 5, 16 or 17, which is. And just whip through these. Well, A is failing to make any primary findings of fact about scale of publication of each of the tweets, or to distinguish between the scale of publication for which the defendant is responsible, the republication by the claimants themselves, and the republication supported of the claimants. Well, she found that these were cases of mass publication. She didn't make the defendant, Mr. Fox, responsible for any retweeting by the claimants themselves. She noted, of course, that he has 250,000 followers, and she had evidence, as she said, I can't remember which paragraph, that there was also, she was satisfied that there was screenshots and quote tweets and so on. I'm sure someone can give me the reference to the screenshotted sentence. Or it probably is, it possibly is 72, 73. Anyway, she dealt with this all at paragraph 72 to 73, and no reference to 72, 73 was made yesterday by Mr. Green when he said she didn't address this. Now, whether she addressed it in the detail that they would like, she's 72 to 73. Demonstrates that she is looking at this. And much was made about the "here we go" tweet and how one has to exclude the harm caused by that. The "here we go" tweet was not a publication put forward as bearing the single meaning. It was put forward as done to try and mitigate harm. It was done to spread mitigation. The "here we go" being, as the judge noted, the damages judgment at paragraph 18, the flagging that, here we go, the homophobic trope, and it was sent to the first claimant's own followers. Moving on quickly to B of ground 5, failing properly to account for his clarificatory statements within an hour. Paragraph 90, she was, for some reason, criticised because I think this was where a straw man may have been used. At paragraph 90, she was criticised for saying about the degree of his 3 tweets of 4th, 5th and 13th contain a degree of stepping back. They do not merit the description of a prompt and prominent apology. It was criticised because they haven't been put forward as an apology. If one goes to paragraph 54 of the defence, I'll just give a reference, core bundle, page 222, they were pleaded to be unilaterally issuing of 3 tweet apologies. Then C on the vulnerability, C1, C2 as gay men. We did not understand, well, we didn't pick this up from their skeleton argument as still being pursued. D, the trolling. She deals with the trolling. Their case on the trolling is not accepted by her. It's her paragraphs 85 to 84 to 86 and 100. E, failing to account for the absolute evidence of any negative effect on the claimant's professional roles whatsoever, and positive evidence to the contrary, well, so be it. She didn't have to find it, which of course is why Mr. Fox was so keen for his part to say, but I'm proving career harm. And then the relying on the support and so on. I mean, these are not. I'll just go to I. Contrary to the direct evidence of C2, the finding that there was, or even could be, a causative link between Mr. Fox's publication and abuse suffered by the second claimant in 22 to 23, no such finding at 102 or elsewhere. And although they continue to harp on about it, the short answer is the ground to which they sought and obtained PTA is misconceived as being directed at finding not made by the judge. So that was a whirlwind tour of a rather whirlwind ground 5. I was proposing now to hand over to Ms. Basuto, unless I
Can I just ask one question? We understand what you say about the single meaning, and there's no attack on the law of the single meaning from the appellant, so we don't need to confront that. But there is, in this situation, the single meaning tweet, which lasts for, on the evidence, some period till at least 9:30 the next morning, when, if all those reading it will have picked up the fact that that is no longer the single meaning. And all we get from the judge in relation to that was a degree of stepping back, perhaps because it had been argued differently. But does that not affect the quantum and the reality of the impact of these matters? Of course, it's still serious harm, but does it? How does that play in?
I think that the difficulty is that there was no overlap evidence. There was no evidence to assist. Something goes out, his 250,000 followers, as the judge records, it's screenshotted, quote tweeted, it percolates out, and one simply cannot make any kind of measure or quantification about who saw what and when. I mean, it's just in the realms of speculation. There's a certain amount or extent to which he says, I'm not taking this account, or I'm not taking that into account. But at the end of the day, that it's unreachable. And of course, one doesn't know everything about the engagements with Mr. Fox's tweets, because Mr. Fox's tweets were deleted, and as I understand it, the metrics or the analytics were not available. So one doesn't know, one doesn't, for example, that's why we don't have impressions for whatever value impressions have. And this is the difficulty with it. Is every court in every Twitter case going to have to try and grapple with these endless scenarios? I mean, one possible thing they could have done, if their case is, as it is, that not a single reader understood it in single meaning, they should have tried, I suggest, a reverse innuendo case and argued that, but they didn't. A reverse innuendo case, if they failed on that, then they could have appealed. But I mean, it's absurd to get to trial where you can say not a single person understood it in a particular way, or understood it for more than a minute or an hour or whatever, where that has not been tackled at the stage of determining the single meaning. So that's all.
Thank you. Mr. Basuto.
my lords, my lady, you might have it open in front of you, but it's ground 7 in the grounds of appeal, page 18 of the core bundle. And we see the points that are taken there. The learned judge's assessment of damages in the remedies judgment at £90,000 for each of the claimants was perverse. I'm not going to read it all out. There's effectively 4 factual contentions as to matters which the judge failed to take account of, and 1 at the end, which is that it's out of sync with personal injury awards. So those are the grounds. My lords, my lady, at the outset, I'd say it's perhaps notable then that it's not submitted by the appellant that the judge made any material error of law in how she went about her assessment. His complaints are purely about her approach to the facts. And I should say, I don't know if I'm going to, well, no, I'm not going to turn it up, but the relevant section of the appellant's skeleton argument, which is at paragraphs 97 to 102 of the core bundle, it's 2 pages long, does not really put much flesh on these bones. Although, I should just say now, it does add 1, possibly 2 new points, not apparently covered by the grant of permission to appeal. In fact, I should perhaps turn it up. So it's page 45 of this bundle.
Of the core bundle?
The core bundle, my lord, yes.
Thank you.
My lords, you'll have seen what the grounds of appeal were. The one that doesn't feature, definitely doesn't feature in the grounds of appeal, for which permission was given, is 101 on page 45, that the judge failed to consider the actual words used by the defendant and the likelihood that many or the vast majority of readers would not have taken them seriously, particularly in their context, as contrasted with the treatments of the words used by the claimants about the defendant, which were deeply contextualised in the judgment. There's a reference to paragraph 16. So, my lords and lady, this is a familiar point. This is the point, indeed, I think, which Miss Page was just addressing in the context of serious harm. So, the court will have already had a flavour of what the arguments are. My lords, I mean, I do take the point that permission hasn't been granted for this, but I think I can deal fairly shortly with what I have to say about it, if the court wants me to.
Well, I think it's probably best just to address everything, because no doubt we'll have an argument that it's covered by ground B, which is fail to account for clarificatory remarks and or positive evidence of absence.
Maybe, well, my lord, I'm grateful. So, I mean, the brief points I'd make on this is that so far as concerns the correct approach to assessment of damages, and I will take your lordship and lady to authority in a moment, but in my submission, the correct approach to the assessment of damages in defamation case, it's very well established that the most important factor in the assessment is the gravity of the libel, and that gravity is judged primarily by reference to the single defamatory meaning. And as Lord Sumption made clear in the Lachaud case in the Supreme Court at paragraph 13, I'm not going to turn it up, but he was referring to the well-known authority of Lord Reed and Black, Clawson International. Parliament was presumed not to have altered the common law any further than was necessary. So, in my submission, accordingly, even if the appellant were right in his proposed novel approach to meaning in the context of serious harm, it would not necessarily follow from that the established approach to gravity in the context of damages needs to be revisited. In other words, what we'll end up with, if the other side are right, is subjective meanings coming in on, or special context plus subjective meanings coming in on serious harm. But in my submission, there's no reason to alter the rules on damages, the single meaning, at least in terms of gravity, dictating what the result should be on damages. We on this side of the court have been able to find a single case in which the court has considered evidence of the actual meaning or reader's subjective views on meaning on the issue of damages, nor any example in the mass publication case of the court conducting a specific, publishee-specific inquiry on the question of damages. And the nearest one comes to it is the Oriental Daily Publisher case, which my Lord Justice Warby referred to yesterday, which, I mean, just to summarise it very briefly, I mean, it's almost akin to a reverse innuendo case. It's a case where the court found that everyone who looked at it must have thought that it wasn't really to be taken seriously because of the particular facts about the publication in question, and extraneous facts which would have been known to most readers in Hong Kong. But that's the nearest one comes to it. There is nothing in terms of damages assessments which fits that bill in terms of the authorities. So before I go on, I should just, the only other point which arguably, just to flag it, the only other point that may be in the skeleton argument, which is not in, at least arguably in the grounds of appeal, is at 102, and this isn't as clear cut, but the point here is that in the grounds of appeal, the complaint about damages being too high is, if one goes back to the ground 7, if you see at 7E, it's tethered to the point about comparison with personal injury awards. By contrast, what we seem to be getting at the end of the very last paragraph of the skeleton argument is that the award is simply excessive, but both awards. At large, as it were, not tethered to personal injuries. But anyway, I can deal with that, my lord, I think fairly.
Well, we'll obviously in judgments have to reflect on all the points you take on
Yes.
the pleadings, but just make the arguments now and we can assess them.
So, my lords, in summary, our position on these grounds and the other arguments is that firstly, there is nothing of any substance in any of the appellant's complaints in the 5 sub-grounds of ground 7 about the judge's approach to the assessment of damages. Certainly nothing that could reasonably support a characterisation of her awards as perverse. And secondly, that if and insofar as the appellant is advancing an argument that the judge's awards of £90,000 general damages to each of the respondents was so high as to be wrong, whether by reference to personal injury award damages or as a freestanding point, it is submitted that his complaint is groundless. On the facts, the judge's awards could quite legitimately and unobjectionably, in my submission, have been 2 or even 2.5 times higher than they were, even factoring in all the matters that the judge took into consideration in diminution of the damages at paragraphs 23 to 33 of her judgment. I'm not going to go there now. My lords, in terms of the principles, before addressing the appellant's specific complaints about the judge's approach to the facts, I think these may be taken conveniently from the judgment of my Lord Justice Warby when he was Mr. Justice Warby and Baron Vines. That's the Damages Authorities Bundle, tab 3. Page 33.
Thank you.
One can go to paragraph 20 in that judgment. And this indeed is certainly an authority, if not the authority, that the Mr. Fox's team cited themselves before the judge. I don't think it's controversial, but it's a helpful distillation of how the court goes about assessing damages. The general principles were reviewed and restated by the Court of Appeal in John. And then it cites what Sir Thomas Bingham, Master of the Rolls, summarised the principles in that case. The successful plaintiff in a defamation action is entitled to recover as general compensatory damages such sums as compensate him for the wrong he has suffered. It must compensate him for the damage to his reputation, vindicate his good name, and take account of the distress, hurt, and humiliation which the defamatory publication has caused. In assessing the appropriate damages for injury to reputation, the most important factor is A, the gravity of the libel. The more closely it touches the plaintiff's personal integrity, professional reputation, honour, courage, core attributes of his personality, the more serious it's likely to be. The extent of publication is also very relevant. A libel published to millions has greater potential to cause damage than a libel published to a handful of people. Successful plaintiff may properly look to an award of damages to vindicate his reputation, but the significance of this is much greater in a case where the defendant asserts a truth, obviously that doesn't apply here, and refuses any retraction or apology than in a case where the defendant acknowledges the falsity of what was published and publicly expresses regret that the libelous publication took place. It's well established, and that deals with aggravated damages, which we don't need to deal with here. And then going back to my Lord Justice Warby's paragraph 21, so 21.21.2, the existence and scale of any harm to reputation may be established by evidence or inferred. Often the process is one of inference, but evidence that tends to show that as a matter of fact a person was shunned and so on will be relevant. So may evidence that a person was treated as well or better by others after the libel before it. 3a, the impact of a libel on a person's reputation could be affected by their role in society. The libel of Esther Ranson was more damaging because she was a prominent child protection campaigner. 21.7. In arriving at a figure, this is dealing with personal injuries, in arriving at a figure, it's proper to have regard to jury awards approved by the Court of Appeal, of course, and that's Ranson and John. The scale of damages award in personal injury actions, previous awards by judge sitting without a jury. I'm just going to lay down a marker. There's obviously a difference between A and C there. A and C is essentially precedent and authority. B, the court has given clear directions that what the relationship is, and I'll come to that. And then finally, just very briefly on 22, this is just about malice, and what my Lord Justice Warby says there is that really malice is only relevant if it's impacted on the claimant's feelings. In other words, they're more hurt in their feelings because they appreciate that the defendant's been malicious. So that's the key stuff that I rely on in terms of how the court should goes about assessing damages. In terms of the appellate test, I think I can take that from, albeit it's a privacy case, I'm going to go to the Court of Appeal's relatively recent decision in a case called Alley and Channel 5, which is in the Damages Authorities bundle at tab 5. That quotes from the Gulati decision, which is perhaps the slightly more authoritative case. In other words, it's authoritatively reported and so on. So if I could take your lordships, my lady, to Alley, so tab 5 of the Damages Authorities bundle, and it's right at the end of the judgment, 118. So this is Lord Justice Irwin at 118. I'm giving the judgment of the court, I think. We would reject the appeal on the... So in this case, it was the damages were too low, not too high. But the principles are the same. We would reject the appeal on the quantum of damage based on ground 1. It seems to us that the judge was best placed to make the relevant assessment of impact. And just skipping down a few lines, we accept that other judges might well have reached a higher figure in an overall assessment of damages, but in this area too, it's important that an appeal court should be slow to interfere with an assessment of damage.
Sorry, which paragraph are you
Oh,
on?
I'm so sorry, 118, my lord. I skipped a few sentences and went to about halfway through the paragraph.
Thank you.
We accept.
Yeah.
So other judges might have reached a higher figure, but in this area too, it's important that an appeal court should be slow to interfere with an assessment of damage. In such a case as this, where the measure of damage is necessarily general and cannot be calculated mathematically, the defendant relies on the principle reasonably restated by the Privy Council in relation to an award of general damages in a personal injury claim, Scott and the Attorney General. The Judicial Committee there emphasised an appeal court should be reticent before interfering in such an award. Then we have Lady Justice Arden in Gulati. So there's a threshold question in terms of appeal on damages cases. If the judge makes a material error of law, this court must intervene. If, however, the challenge is the size of the award and the judge has, as here, heard the evidence of witnesses in assessing the effect on the respondents of the misuse of their private information, This court should not intervene unless the court is so high as to be perverse. The judge will have performed and been better placed to perform an assessment of all the relevant factors, and it is not enough for this court to conclude that it would have made some different award. The same approach must be followed. Of course, that's relating to too high, but this is a too low case. Those are the principles. I mean, that's a privacy case, but my submission is that it's indistinguishable. In fact, it's exactly the same approach in relation to defamation, damages. If one wants to see a defamation damages case on this point, one can look at Blakely Williams. I'm not going to turn it up. That's in the Damages Authorities bundle at tab 1. And it's Lord Neuberger in that case at paragraphs 82 and 93. That's another decision of the Hong Kong Court of Final Appeal. There's Oriental Daily Publisher, and there's an account given in that case by Judge Ribeiro at 35 to 37 and 45 to 46, which is completely in accord with what Lord Neuberger, he was also sitting on that tribunal. The two go hand in hand. And I would simply note that Judge Ribeiro in Oriental Daily Publisher cites Dingle, and that's Lord Radcliffe at page 393, with whom Lords Morton and Cohn agreed. And it's precisely the same approach. So those are the cases. And to summarise it, my Lord's question is, are the awards of damages so high to be outside the ballpark? The question then is, what is the ballpark? And my Lords, I think the key case on this is Cairns and Modi, which is in tab 2 of the authorities bundle, decision of the Court of Appeal. If I can invite you to turn that up, please.
Page?
It's at page 17 of the bundle.
Thank you.
And I think we can go, please, to paragraph 24 of Lord Chief Justice Judge's judgment. And as he points out there, the process of assessing damages and libel is not quasi-scientific. There is rarely a single right answer. Nevertheless, it's virtually self-evident that in most cases the publication of a defamatory statement to one person will cause infinitely less damage than the publication of the world at large, and so on. Then one could skip down to 25, which cites John, and then just below D in the margin, it has now become conventional also to recognise and effect a ceiling figure, allowing periodically for inflation corresponding to the current maximum level of damages for pain and suffering and loss of amenity. In Lilly and Reed, it was taken to be approximately 200,000. A few months earlier, such a ceiling seems to be recognised as appropriate by Lord Justice Simon Brown and Khayyam. The present equivalent, this is in 2013, my Lord, allowing for inflation without taking account of any uplift consequential on what are usually described as the Jackson reforms, would be of the order of £275,000. And using the Bank of England inflation calculator on its website, that would seem to take us today, allowing for inflation to something like £396,000.
Has there not been an update in the guidelines?
Not that I'm aware of. I mean,
The personal injury guidelines.
I usually would go to the personal injury guidelines.
right. Well, I don't.
For tetraplegia, that's where that comes from.
Right. Well.
Yeah.
All right.
Well, I'm sure that we can be provided with that.
I just simply took the figure that Lord Judge had taken and used the.
Yeah, but I think it goes back to a comparison with the maximum for
Yes.
tetraplegia, which is the highest
Right.
award for pain, suffering, and loss of immunity
But-
and personal injury. So we can find out what that is.
Yeah. I mean, I would guess it's going to be around that figure. I mean, maybe slightly out, but it's going to be something like that.
Well, I think it's gone up by 10% for other reasons.
Yeah.
That was to do with the cost reforms.
Yes. Yes. All right. So, and just dealing very briefly with there were two cases in Cairns. There was Mr. Cairns, who was a New Zealand cricketer, and he was awarded £90,000 in 2013 for publication of a tweet accusing him of match fixing, primarily to 65 readers, but there was a very heated defence of truth at trial, which failed, and allowing for inflation, that would seem to be an award of £130,000. Now, that's not so relevant to our case. Perhaps what's more relevant is the KC appeal. What happened there was KC was the father of baby P. He was never identified by name, and it was accepted, certainly by the Court of Appeal, that very few people would have known who he was. The award at trial was £150,000 as a starting point for an offer of amends case, which then had to come down due to the sort of discounting factors on an offer of amends. But the Court of Appeal took that down to £100,000, but obviously they still accepted that £100,000 was an appropriate starting point. And that concerned a false assertion that a man of good character has been convicted of the rape of a child at 41 in the judgment. And that would seem to be about £144,000 in today's money. In terms of other awards, I'm not going to hand it up, but in the...
Sorry, where are we?
Sorry. What
KC?
Oh, KC, sorry, yes. Paragraphs 47 to 48, my lord. Sorry, I'm just moving too quickly here.
Yeah.
Yes? Thank you. I'm not going to go to it, not least because it's not in the bundle, but there's, if one wants to look at the earlier Court of Appeal damages awards, there's an appendix to Gatley, appendix 3, I think, which sets them all out. The only ones I would highlight are the ransom case itself, in which the Court of Appeal approved an award of £110,000 in the early 90s, which was an allegation that Esther Ranson had shielded a teacher sex offender, concealing his admitted crimes after setting up Childline, an organisation to protect children from sexual abuse. So at least it's in the territory of sexual misconduct, serious sexual misconduct. Houston and Smith, which is a bit of an old chestnut, but that was a slander in a doctor's waiting room, an allegation of sexual harassment, where the award approved was £50,000, which is £108,000 in today's money, I think. And then the only other one I'd just note, for your note, is Campbell and NGM, which is a rather peculiar case, but it's just the part in the note which says that had there not been all the problems with the claimant's conduct, it would have, the imputations would have justified an award at the highest end of the spectrum, and those were allegations of serious sexual misconduct as well. So, applying all of that to this case, I'm going back to ground 7, please. I've already made the point that none of these complaints really touches on gravity and the scale of the publication, which certainly the first is specifically recognised by Sir Thomas Byng in Master of the Rolls as being the most important factor. Given that is so, it's perhaps worth bearing in mind when considering the appellant's complaints that objectively the position on gravity and extent of publication of the libels presented itself to the judge couldn't have been more serious. Could hardly have been more serious. Indeed, it seems very much like the proverbial case at the very top of the range of seriousness of libels, which may properly attract the largest award of damages. So, for example, and I won't turn it up, Mr. Justice Bean, as he was then in Cook, which is in the Liability Authorities bundle, referred at paragraph 43 to a national newspaper with a large circulation wrongly accusing someone of being a terrorist or a paedophile. That's what he envisaged at a case at the top end of the scale. My Lord Justice Warby in Monroe and Hopkins at first instance, having identified the overall ceiling at that time as £300,000, that sort of award is only suitable for the gravest of libels, such as widespread publication of allegations of genocide, terrorism, or murder. I hope it's not too much of a stretch to say one could add, presumably, to that criminal paedophilia. These were libels of Mr. Blake and Seymour, which imputed to them, as Mr. Justice Nicklin held and this course endorsed, that each was a paedophile, someone who had a sexual interest in children, or who had or was likely to have engaged in sexual acts with or involving children, such acts amounting to serious criminal offences. So that couldn't be more serious, I'd submit. And that's reflected in the judge's judgment, both judgments. Extent of these libels, 250,000 followers on Twitter. Without labouring the point, this is more or less similar to the print circulation of some national newspapers at the time Mr. Justice Bean made those remarks in 2014. I mean, in those days, the Guardian's average daily circulation was 185,000.
Is this permissible on an appeal? I'd stick to your better points rather than try and give us new evidence.
Well, my lord, it's a matter of public record.
I know that.
Yeah. All right. All right. But the point is that in contrast to a newspaper, these matters are beamed directly into people's phones or computers. It's unfiltered, it's unmediated. They're sitting around on a Sunday afternoon, and this is what they're scrolling through. And in my submission, that does bear a significance in terms of...
Is that a factor the judge relied on?
Sorry, my lord?
Is that a factor on which the judge relied?
No, it's not.
Because it might equally be said that people don't look. Because people read newspapers, they pick them up, and they look at them. So there are all sorts of...
Well, I accept that, my lord.
Not that you're wrong, but it's just not necessary for us to make this decision.
No. Well, I mean, it's a simple point. It's a take or leave it point. I mean, there were obviously inferences going... There were a lot of inferences being drawn, or attempted to being drawn, about what the correct level of readership was. In fact, I think Mr. Green said it could have been much higher than 250,000 people. But of course, there's always going to be questions as to who read what, and the court can only really try and do its best. But anyway, it's a very substantial publication, as the judge did hold. I mean, mass publication and a lot of people. All right, so against that background, my lord, and as quickly as I can, I'm now going to turn to the specific complaints. So, Complaint A has failed to account whatsoever for the conduct of the claimants prior to and shortly after publication by Mr. Fox, including in provoking the libels by attacking Mr. Fox and their express malice and ill will towards the defendant. I mean, the first point I'd make is that the skeleton argument of the appellant says nothing in paragraph 99 or otherwise in that brief 2 pages of their skeleton on damages about any alleged conduct of the claimants shortly after publication or their supposed express malice or ill will towards the appellant. So it's assumed that nothing other than the provocation point is being pursued by them. But in any event, I should say the judge made no such findings about those matters.
Did she make any findings at all?
About malice or...
No, provocation.
Yes, she did. So far as concerns provocation, my lord, the central point here is that just because there is a particular established basis for a reduction in damages, e.g. provocation or an apology, doesn't obviously it does not follow from that the judge is relieved of the obligation to analyse the specific case presented to her by the defendant on the facts and to work out whether that fact indeed amounts to provocation or an apology so as to be capable of mitigating the damages. In A40 ori, it's not illegitimate for the judge to take an analytical approach to those things. I mean, I recall, my Lord Mr. Justice Warby in Le Show, for example, in respect of one of the defendants had published, they said, an apology, and at paragraph 146 of his judgment in that case, he dismissed the idea that it was a proper apology or that it should be taken into account in mitigating the question of being evidence of mitigation of harm. And indeed, there's another example similarly in Dingle. Against this background, we submit that the judge was not wrong in taking the approach she did at paragraph 22 of the remedies judgment, which one can find at page 158 of the core bundle. She says, I also reject, including for the reasons set out in the liability judgment, Mr. King's counsel's contention that the claimants brought this ordeal upon themselves in any material way capable of standing in damages by provoking Mr. Fox's libel, engaging in a lively, even rude or offensive online debate about provocative call to boycott Sainsbury's, did not on any fair analysis invite the response Mr. Fox visited upon them. Mr. Blake and Mr. Seymour are absolutely entitled not to have Mr. Fox publicly call them paedophiles. And that's entirely consistent with what she said about reply to attack as a defence. And in our submission, she does deal with it. The way she deals with it is unexceptionable. And she was entitled to look at the case presented to her and decided it wasn't provocation which could reduce the damages.
I mean, the question is not whether they brought it on themselves, etc., in terms of justifying making it less objectionable as a matter of law, but whether it's a relevant factor. If I call you an offensive name, it's not surprising that you call me an offensive name back. It doesn't justify you calling me the name back, and you might be liable for it, you might not. It doesn't justify me doing it. But to leave it wholly out of account, is that fair?
Well, in our submission, yes, because on these facts, she didn't accept that and was entitled to accept that the response was within the ambit of an acceptable response to the alleged provocation. She didn't accept that it was provocation in the sense known to the law. I mean, it may be in a sort of lay sense, but not in the legal sense that she felt was required to make it relevant.
But these are all about words, and I mean, if I'm responding, if I call you out of the blue,
yes,
a paedophile,
yes,
it is, one might think, very different from responding to you calling me a racist.
Well, I mean, certainly that's Mr. Fox's argument.
No, I understand that. I want your submission in response to it.
My submission, in short, is the judge got it right. She was entitled to not treat it as a matter reasonably capable of reducing the damages on the facts, on the very specific facts, as she found them.
Thank you.
I mean, the point being, essentially, my lord, that there was no apparent connection, she found, between the alleged provocation of Mr. Fox, of the claimants calling him a racist, and him in return calling him a paedophile. And as I say, I've already referred to them.
Well, that might explain the different legal results on liability, but it's the question related to quantum.
Yes.
Yeah, thank you.
My lords, in terms of apology and clarificatory remarks, I'm not going to spend too much time on that. Again, she dealt with that point at 25. And she records the various things that Mr. Fox did. And she concludes that it did not amount to an apology directed specifically to the claimants for the experience and harm it had inflicted on them. Nevertheless, Mr. Fox took down and did not repeat the libel and went at least some way to distancing himself from it. I take that into account in his favour. So in other words, she gave him the credit that she felt he was due for having done that, but she didn't accept it was again in the libel sense, and there's authority on this, a proper apology, one that retracted and if it needs to be apologised, but essentially it wasn't something that retracted.
Well, one can see the force of that in relation to distress.
Yes.
Because apologies are meant to limit the impact on people's feelings. Does it have the same force in relation to reputational harm? I mean, the argument against you is that he said it's all nonsense, and so people would have known that it was false, and that mitigates the reputational impact.
Yes. Well, I I mean, we know from Cook, for example, that in theory, an apology might be, prompt apology might be so powerful a mitigation as to remove serious harm. And that's all to do with reputational damage, nothing to do with distress. So as long as... So
Well, it's got to be, the impact has got to be on the views of third parties, not on the feelings of the claimant. That's the point. Whatever you call it, whether you call it a retraction,
Yes.
apology, statement, whatever label you give it, the statement can only mitigate damage to reputation if it has an impact on other people's views.
Yes.
And whether it has an impact on the claimant's feelings is a separate question, although it may be related. So the issue that he should have been addressing, it might be said, is impact on reputation. And do you say that that's what she did in this paragraph?
Well, I mean, it seems to, the way she frames it, it seems to be going to reputation. But the point is that what he did only went to his own followers, apart from anything else.
Yeah. And she does say it didn't amount to a retraction in terms of approaching those on which it was unqualifiedly made. So that's a reputation point.
But the criticism in the grounds is that she failed to account adequately or at all for the defendant's apology. And on her view of the facts, they don't get a base 1 on that.
And all clarificatory
Yeah.
remarks.
Well, yes. I take that point, Mum.
I mean, that's what we're really looking
Yeah,
at.
yeah.
Because she's found it's not an apology and
Yes.
Mr. Green hasn't
But
really...
I mean, in terms of
expressed
clarificatory remarks, in any event, it's only going to his own followers. It's not making a clean breast of things.
it. Well, yes, although the original publication is to his own followers. So you would have thought that's...
It's like retweeted and republished, percolated. So moving on then to C, which is that she failed to account for the claimant's misconduct during the litigation. I think I could deal with that very shortly, which is she made no findings of litigation misconduct at the trial. Barely touched upon at the trial.
Was she invited to?
No, she was not.
Sorry.
She was not invited to make findings about litigation misconduct. I mean, I've been through their submissions, and without going through it in detail, I mean, my understanding is certainly by the time we get to closing submissions, I'm not going to turn up submissions, but
Yeah.
that was not, in any real sense, in play on damages, or indeed at all.
Thank you.
So just bear with me, my lord, because I see I'm over my time already. I think I'm just going to have to do this probably by
We've dealt with 7E already.
Yes, so D, yes, well, I mean, E is simply that there is established authority for
Yeah.
what the relationship. It's a very weak one, if I could put it that way. And as for D, this is a point we have touched on already, which is this business about she failed to account for the claimant's own republications. Miss Page has dealt with that on Serious Harm this morning. We say that she dealt with it entirely properly, both in her liability judgment and in her remedies judgment. And she did not make the error that seems to be imputed to her there, that she did attribute our own republications, albeit in the sort of contextualised, here we go form. She did not rely on that. There is no trace in her judgment that she relied on that in support of her awards of damages. Just to give you the reference in the reference in her judgment is 72 to 73 of the liability judgment, and it's 17 in the remedies judgment. I've dealt with the other ones, my Lord Justice Warby said. So in short, my submission is that these awards were not out of sync with other awards for libels of this gravity, extent of publication, even taking account all the mitigatory factors that the learned judge did. It could have been higher, could have been lower, but I mean, it was not, nothing she did in it was perverse. And in my respectful submission, it should not be interfered with by the court.
Thank you very much. Disagree.
Mr. Callis is going to go first.
Ms. Callis, and we'll give you till 5 past if you need it.
My lords, my lady, 3 points in reply on ground 4. The first, it's quite right that there was no reverse innuendo in this case. We also say there couldn't have been. Seem to remember in Wright and McCormack, not the one that ended up in the Court of Appeal, but the attempt to come to the Court of Appeal from the PTR, the defendants had pleaded an innuendo higher than the claimant's meaning by relying on third-party publications. It was my Lord Justice Warby who rejected that on the basis of Aster and Camplin. Given that the extrinsic facts here that would have changed the meaning would be third-party publications, we say that Aster and Camplin would have meant it couldn't have been a reverse innuendo. And that's important because in a reverse innuendo, it might well have been our burden to prove those extrinsic facts. But we say that we're running this case somewhat differently. We are saying that the incorrect assumption that the actually understood meaning was proximate to the single meaning is something that bars the very inference that the judge drew, the normal inference that you can take the inherent gravity from the single meaning. So it's still a matter that where the legal and evidential burden falls on the claimant, they seek to satisfy it by way of inferential case. And our case is that there is an assumption that fails that prevents that inference from being drawn. And so that would explain why there's no witnesses from the defendant's side on what they actually understood the article to mean. The second point, I think it was put like this, that evidence of what people actually understood is inadmissible except on an innuendo or reverse innuendo. I think that's the way that my friend Ms. Page-Counsel put it in her submissions. Now, that's a remarkable submission for at least 4 different reasons. Because it would appear that the case being put in this court is that the single meaning necessarily governs the inferential case, and so the court cannot consider, as it were, actual meaning and the extent to which that departs from single meaning. Now, that would almost take us back to the irrebuttable presumption at common law. It would seem to reverse at least the effect of the Supreme Court's decision in Le Chaux. We are not suggesting that there should be any change to the single meaning rule. We are merely saying that whilst the single meaning rule continues to determine whether the words are defamatory at common law, and it necessarily determines the ambit of particular defences, whether opinion defence is available, or meaning is necessary as a component of determining the sting for the truth defence. What we are saying is that single meaning does not have an intrinsic role to play in serious harm, since the Supreme Court made clear that that was a question of subjective fact. It just doesn't have a role to play. So it's wrong in those circumstances for my friend to have pointed to paragraph 21 of Le Chaux, where Lord Sumption talks about the judge's exercise at first instance and says he relied upon the inherent gravity of the meaning as attributed by Sir David Eadie. That's descriptive of the process that my Lord Justice Warby had taken at first instance, but it's, again, not a prescription as to how it should be done. The 4 reasons that this cannot possibly be correct is first, it not only takes us from the Supreme Court's decision back to the mistaken Court of Appeal that there was some sort of rebuttable presumption that the defendant could rebut by evidence, it takes us back a whole step further before Le Chaux at all, trying to make the presumption irrebuttable if the evidence of what people actually understood it to mean wouldn't be admissible at all. The second problem with it is it also means that Mr. Justice Nickling, his judgment at Core Tab 21, to which I took the court, is just abject nonsense. He said that the reason that his ruling on directions to the TPI didn't render these proceedings unfair was because we would be able to argue this at final trial. Not only were there crickets, there was no challenge to that whatsoever from the claimants in this trial, but when one sees, and I mention this only for my lords and my ladies' note, Their trial skeleton argument, Sut Volume 4, Tab 3 at page 41, paragraphs 36 to 38, repeated in their closing, Sut Vol 4, Tab 9, page 179, at paragraph 6 to 7, except that different readers will have understood it different ways, that reputation will have been harmed in some ways and not others. So, even if it weren't for the fact of Mr. Justice Nickley's judgment being rendered a nullity by the argument currently made, the third point would be there's surely an issue of estoppel or some sort of Henderson abuse in the fact that this point has never been taken before, and there was no appeal against the order of the PTR that granted us permission to amend, which moved the contextual case from meaning into serious harm. So the point can't be taken now just on fairness grounds. The fourth and rather more obvious point is there is no respondent's notice in this case. The claimants are upholding or seeking to uphold the judgment that the judge actually gave. Your lordships and your ladyship will search in vain for the judge's determination of this point, let alone that she decided on the law that only the single meaning could be considered and that our entire case on actual meaning had to fail for legal reasons. That's certainly nowhere there. The third point is the consequences if this submission were right. If serious harm were to be governed entirely by the single meaning, and somehow that didn't offend against the Supreme Court's decision in Lachaud, one is left with a very strange situation addressed in paragraphs 71 to 75 of our skeleton argument. This is Core Tab 3, pages 38 to 39. So this makes clear that our primary case is that the single meaning rule has no particular application in the determination of serious harm. Sorry, forgive me, my lady, just one moment. Primary case in para 71 is that single meaning, properly understood, doesn't have a role, save that it is a good proxy in many, if not most cases, for actual meaning. And that's why the inference normally works, but doesn't in this case. But our secondary case is that even if insofar as it was a relevant factor, or it was bound to it, that sits very ill with one of the two assumptions that the judge did consider, which is the case of belief. Because if single meaning is to govern serious harm in the way proposed by the respondents to this appeal, then the fact that the judge has said, I observe in this connection that contrary to some submissions made to me on this point, it's not necessary for the claimants to establish a probability of readers being immutably convinced of the allegation. That's not how reputation works, it's the bad odour. We say that makes something of a mockery. If the single meaning, with the gravity of its imputation, is to be used to found purely inferential cases of serious harm, it surely has to be because readers believe those. We know that evidence of belief can be taken into account from the cases that my Lord Justice Warby mentioned, including that of Oriental. The idea that an inferential case could be based on serious harm because of a Chase Level 1 meaning, when nobody believed it in Chase Level 1, and they believed a meaning other than the single meaning, would make an absolute mockery of the law. And we give two examples of why that would be problematic. On our imputation, this doesn't arise, but there will be matters that are defamatory at common law at Chase Level 1, but might not be at a lower Chase level. But the other point is that a defendant might be able to justify a lower Chase level, and the finding of single meaning precludes that as a defence of truth. But then, if it goes through at Chase Level 1, nobody believes it at Chase Level 1, and readers only believe it at a Chase level he could have defended, but is precluded from doing so. The single meaning wreaks a form of unfairness that it hasn't done, even in the circumstances that we're familiar with. So there is a policy question: does single meaning irrebuttably govern serious harm inference cases? And we say that's obviously not the case, even if it's the case that had been made before today. Unless I can assist any further, my lords, my lady.
Thank you very much. Mr. Green.
My lords, my lady, just on that point, the short point is that within, if they didn't, to Mr. Fox's followers, he did the tweets to his followers, Mr. Fox's followers immediately know that within the hour that language is powerful, and that tweet, that casts serious doubt contemporaneously
we have the "here we go" tweet that is not addressed at all in the liability judgment within 3 minutes, almost simultaneously. We have the combination of all three tweets with one that includes obvious mimicry, as the Court of Appeal has already held. And we know that by first thing the following morning, Mr. Fox himself had tweeted that the allegations were baseless. Now we know that his language is powerful tweet got about 1.1 million impressions, absolutely enormous. Probably many multiples of the original tweets individually. We don't know how many his deletion tweet, where he said they're baseless, got, but the court will remember my submissions yesterday in relation to the very particulars relied on by the claimants about the Julie Hartley-Brewer interview that morning, which laid the ground for the media conversation that went national thereafter to millions and millions of people, in which, at the first opportunity, he clarified that the allegations were baseless. So the first thing is everybody knew by the following morning, or in the immediate days that followed thereafter, that the allegation was an absurd allegation to have made, it was without any foundation, and it wasn't to be believed. There is no cohort of reasonable readers that would not have known that once it's been through the tumble dryer of the national press, which amplified that message nationally. And that was the claimant's positive case. Even before the national press reported what Mr. Fox had said to Julie Hartley-Brewer, that it was baseless, the claimants were claiming that that interview was what had amplified it. So there are 2 points. One is there is no real case available on the facts as they actually happened that there was harm sustained rising to serious harm. It just isn't. And the second point is the judge just didn't deal with those points. And where she did and tried to deal with baseless, she did so in a way which is completely irrational. I'm going to briefly just deal with remedies because that was freshest in the court's mind, and then go back to a few points, if I may, on liability. With greatest respect, some of the submissions on remedy were extraordinary. The suggestion that misconduct was not an issue, if the court looks at bundle S4, page 366,
366.
366.
Thank you.
So 357, we're in tab 12. 357 is the beginning of the defendant's skeleton argument on remedies.
Yeah.
And we look at 366. And that's setting out the law in relation to factors that may affect.
Yeah. Well, it's a very well-known passage.
Yeah, exactly. I'm not going to labour it. If we go to 368, paragraph 24.1, there's reference to Campbell, claimant's misconduct during litigation. I'm building up, my lords, you'll be pleased to hear.
Because it isn't addressing the point directly at the moment. Yeah.
Not yet. And then it lands on 373. Other factual matters before the court. There is a heading, paragraph 34, litigation misconduct. This is the skeleton argument for the remedies hearing itself.
we've looked at this issue since then in Wright and McCormack, and it's not just any litigation misconduct that bears on damages, it's relevant misconduct. If you're dishonest, and the imputation is one of dishonesty, one can see the relevance of it.
Well,
but if the allegation is one of paedophilia, the way you behave in relation to disclosure is hard to link, isn't it?
well, if it's
What's the rational
well, there was,
basis
for example,
for
my
reducing
lord.
damages because people have been a bit dodgy in their disclosure, as you say?
Well, there was a signed statement claiming privilege which was untrue.
So what? They're not
Well,
claiming
that's not
damages.
honest.
They're not claiming vindication for an allegation of dishonesty. I mean, I don't. What's the logical
Well,
connection?
we also prayed and aid the exaggeration of distress. I mean, the problem is that the judge doesn't actually deal with any of the underlying matters for us to rely on. And I take your lordship's point. You also dealt with the exaggeration of reputational harm. And we dealt also at H with really serious abuse and unpleasantness by Mr. Seymour's husband over a very long period.
Yeah.
Right up to trial and tending to flare when there was a court hearing. So I was just clarifying that it was an issue. I take your lordship's point.
Yeah.
There's a question for the judge to say, well, I find this was serious enough or wasn't, and is relevant or isn't. And it was an issue.
And does the judge deal with it at all then?
No, that's not mentioned. Provocation, your lordship's questions indicate you've already got the point. I'm not going to deal with it further. But
what do you say to Ms. The response from Mr. Bissattle?
well, first of all, it's not an available view that they didn't provoke it at all. Secondly, it's based on a, if I may say so, quite extraordinary version of the facts in the liability judgment. And that's no better illustrated than by paragraph 93 in the liability judgment at page 132.
Sorry, 93.
93,
Yeah.
page 132. Now, the context of this, my lords and my lady, you'll remember yesterday I showed you how the judge, when she was dealing with extent of publication, left it completely out of account the fact that they called him racist in those terms. And the learned judge's characterisation at the bottom of 93, 4 lines up from the bottom, Miss Thorpe's question about what exactly was his objected to Sainsbury's was objectively fair and in that context unsurprising. Readers had not been rhetorically primed to understand that according to his own lights, Mr. Fox was obviously challenging racism, not exhibiting it. Now, it is quite extraordinary. There are only 2 ways that can be being expressed. One is her original tweet, and the other is a later question that she asks Mr. Fox on Twitter. What's your real objection? It is bizarre and grossly unfair to Mr. Fox not to face up to the actual words that the claimants used in their tweets. And that was an overall criticism of the learned judge's approach, which all she does is take the sting of racist, and she ignores throughout the liability judgment the way in which that was expressed, in intemperate terms and unnecessarily offensively, as I mentioned yesterday. So, it's just not an available view that they didn't provoke it, and that there should be 0 reduction. There was no provocation at all. That obviously was. They started it. And also, the idea that somehow Mr. Fox's position on Sainsbury's was provocative, because the learned judge finds that. But Mr. Fox's general point that he made about Sainsbury's, on which, frankly, on the law he was correct, or certainly arguably reasonable in his view, that's apparently really provocative. But then turning around and calling him a racist when you haven't even bothered to click on the link, totally fine. That's all marvellous.
She did click on the link.
well, either way, my learned friend says, Miss Thorpe, I'd forgotten that, if that's right. But anyway.
That's what I understand, that Ms Thorpe's evidence that she did click on the link.
Yeah, so,
That was her evidence at trial, Ms Gris.
well, I accept she may have clicked on the link. That makes it even worse. For a different reason.
Fine, you've still got 10 minutes.
Because she then knew exactly what he was doing,
Yeah.
and therefore it's not reasonable. So, can I just ask the court to look at remedies, judgment,
Yep.
paragraph 18, it's C11157. And it's paragraph 18. I just want the court to have in mind this, because it was a tectonic point on liability, the "here we go" tweet. The judge's total failure to deal with it at all. It is wrong to say the judge doesn't ever mention the "here we go" tweet. What she does do is she references it only in the context of exacerbation of the reputational harm. So the only reference is in paragraph 18, which is the vulnerability to reputational harm by this libel was exacerbated by national profile and safeguarding matters by their respective livelihoods. The claimant's evidence, which I accepted, was their experience of libel and its consequences as distinctively homophobic. There are brackets, their immediate responses, here we go, indicating in context recognition of a well-worn trope. So the only reference to "here we go," omitted entirely from the liability decision, is to exacerbate damages. And that is, well, I'll leave the court to form the court's own view about that. My lords, my lady, can I make one very quick point on the inference? The learned friend said that gravity wasn't, gravity and the general case was not emphasised. E3 was where it was in the closing submissions. The closing submissions focused on what was most in issue. It had been accepted, it was common ground that an inference can be drawn from gravity of allegations. We weren't scared of an inferential case because the defendant's position was completely different. The allegation against the defendant was not contended to have any context that changed anything. Indeed, they supported it with honest opinion and truth all the way through to trial. So there was no sensitivity about that. And it is not, the exercise that the learned friend says was done by the learned judge from J113 onwards, I mean, is absolutely not what should have been done, because what the learned judge says is she says, yes, grave, yes, particularly grave for Mr. Fox because of standing in politics. But then what she does is water that down for impermissible reasons, which we've addressed in our grounds of appeal. Opinion, etc., etc., etc. So that, with greater respect, does not work. The learned friend quite rightly corrected me about Miss Thorpe's job, and I'd accidentally referred to paragraph 11 when I should have referred to paragraph 10 in her witness statement, which is at page bundle S1, tab 332. Paragraph 10 explains that she had regular appearances on television. She was in Coronation Street, the biggest soap opera in the country. She was the learned judge's observation about Z-list celebrities at 139 on page 142 is extraordinary, given her Twitter profile and the number of impressions, which the judge completely ignored. She was not a Z-list celebrity for those purposes. The judge could have checked about whether her influential position had made any difference by looking at the number of impressions of the tweet. So the other quick points, if I may, I think I've probably only got time for very few of them. Very quickly, causation on material contribution was common ground. That was agreed by the claimants, S4 tab 3 at 51 for trial, and was addressed by us in our closing paragraphs 98 to 110.
Sorry, S4, which page?
S4, their one was S4 351.
351, thank you.
And ours is S4 10 88 to 92. The claimants all had lots of followers. C1 had 17,000, C2 had 63,000, and C3 had 52,000 followers. So impact was very important. My lords, I should say this. The learned judge refused declined to determine the truth defence. We understand, and that was refused as a ground. But all of the matters that were relied upon, including the milk bottle point referred to by the learned judge as having had no satisfactory explanation, all of those matters were matters to which Mr. Fox had a good answer and gave those answers in his written evidence. And for example, the 1917 issue, he thought it was tokenistic casting. When the history was explained to him,
We've read the judgment.
he apologised.
The evidence.
And in fact, what doesn't come out in the judgment, I don't think, is that he said, actually, having known the contribution that the Sikhs made, there should have been a whole company of them in the film, because that would have more accurately reflected what happened. So the court has that. But the one that really stung was the finding on the glass of milk point, to which the judge found she was given no satisfactory explanation. And that is an astonishing thing, because the allegation, I'll give the court the references, Core 18261, was that he incorporated into his Twitter handle a glass of milk symbol widely adopted by white supremacists in the USA, continued to use that even if after it had been pointed out to him that it was used by white nationalists and pointed out to him by a Metro article. And in the trial, he explained he never saw the Metro article. There's no reason why he should have done. And he also gave a full explanation of why he'd done that at 19.5, paragraph 19.5, in the reply and defence to counterclaim, Core tab 19, 275 to 276. And in his witness statement, he responded, and it was not put to him that during the trial that he'd done that with knowledge. It was accepted that he didn't know by Ms. Skinner, and the reason he did it was because it was relating to lockdown, where you could go out to get a pint of milk, and there was a Hansard extract which is in the bundle at SUP 1 76 359 to 361, where this has been mentioned in Parliament, and there was a contemporaneous photograph of Mr. Fox with Richard Tice and a pint of milk, making that rhetorical point in Parliament Square at the time, SUP 1 77 362. And that was the references in the transcripts, if the court wants to see that, are internal pages 242 to 247. This is in T5, tab 5, at particularly at page 247 of bundle 5, and at submissions on that in day 8 in bundle 5 at 346. So it wasn't put to him in that way in the trial, and it was something for which he gave a completely good explanation. And the learned judge doesn't even recite what the explanation was, and makes an adverse finding on something effectively as to truth, because that's hinting at truth at the very lowest. So, well, I don't have obviously time to go through all the points in response, but all I would say is there are fundamental flaws with the submissions made by my learned friend. For example, on the 28.3 point, going to bad reputation and so forth. I mean, the first flaw with that was there was absolutely no evidence that Sue Latimer had seen any of that material. There was no link at all between the material relied on and Ms. Latimer's decision. And what was not grappled with by the learned judge when she's juggling is how her view about this can be reconciled with Sue Latimer's support for what the judge apparently thought was a controversial, and we can infer from her treatment of Mr. Fox in the judgment, an unattractive position at question time. Now, Sue Latimer's response, despite the fact that she's in the arts where perhaps a more anti-Mr. Fox view might have been expressed, her response is unequivocal that the response was totally over the top and very supportive. And his evidence was he enjoyed a warm relationship with her all the way through. So there are many, many more detailed points, but time doesn't allow me to proceed.
And also, detailed points are not really for reply.
I'm most grateful.
Thank you very much indeed.
Unless there are any other matters I can assist the court on.
Good. Thank you very much. Well, thank you all very much indeed for all the hard work that has obviously gone into preparing for this. It won't particularly surprise you to know that we won't give judgment this afternoon, and so we'll reserve matters. The judgments will be distributed in the usual way, subject to the Council of General Wales embargoes. And we are required to warn everyone who gets a copy of the judgment that those are strictly enforced, and it would be very disappointing to get into issues of contempt. Thank you all very much indeed, and we'll try and give you a judgment as soon as we can.